So the last session is related to access to justice. We have a few speakers up here today. I will be introducing Michelle Lamazzo. She's a bencher and she is the founder of Lamazzo Workers' Compensation Appeals. Michelle will be speaking to us today about paralegals and law libraries.
Good morning. So it's my pleasure to be here with you this morning, and I'm thrilled to be given this opportunity to speak about access to justice and paralegals. I hope to have some time at the end of my presentation for questions. So thank you, Doug Judson and Ian Hugh, for inviting me to speak, and thank you both for all of the support that you've given to me and for the acceptance of paralegals in general. So I'd like to begin by asking each of you to think of a few things that come to mind when you think of paralegals. Okay, now my second ask is to park those thoughts, just for now, and allow me to share my perspective on the paralegal profession. I'm going to start by sharing my career as a paralegal and what brought me here before you today. And that's not because I like to talk about myself, because I don't. But it's because I want to ensure that there's an in-depth understanding of what licensed paralegals do and how we fill the access to justice gap. So I've done WSIB, so Workplace Safety and Insurance Board Appeals, for about 35 years now. 16 of those as a licensed paralegal. I do appeals at the operating level, so I handle case manager appeals, then I represent clients at hearings at the Appeals Services Division, which in this post-COVID era usually means written submission appeals, unless it meets the criteria for an oral hearing, which in today's terms means a hearing by Zoom. And then, in my appeals process, if the Zoom hearing is not successful, we move on to the tribunal, the Workplace Safety and Insurance Appeals Tribunal. So let's talk a little bit about my area of specialization. I have done exclusively WSIB appeals and workers' side only appeals. And as I've said, I've done them for 35 years now. And the area, the kinds of appeals have varied from a simple ankle twist injury to a client who injured just about everything, from reaching to catch a die that was falling. A die that weighed 65,000 pounds, and he blew out both his elbows, his knees. It was insane. And then other appeal claims that have ranged from carpal tunnel injuries, from repetitive strains, working at any automotive part companies. And then to injuries or diseases arising from occupational diseases, like cancer claims. For instance, non-Hodgkin's lymphoma for workers working spraying weed killer in the 1980s along northern side roads, where they were killing the weeds around telephone poles or hydro poles so hydro workers could climb up to do their work. And the weed killer contained a chemical that I'm sure many of you have heard of, at least the common name, Agent Orange, as it was referenced decades ago. And unfortunately, unbeknownst to these workers, who were so hot in the summer, working up in the Muskoka region, they sprayed each other to keep cool. And in fact, they even drank from the bottle because their employer told them it was safe. So, only decades later to learn it wasn't safe at all. My favorite part about WSIB appeals representation work is that every case is different. One day it's about accident entitlement. The next day the issue is vocational rehabilitation. How do we get that worker who's injured their back or can't do the job that they've done their entire life back to work doing something different? The next day, it's an employer's appeal. The employer doesn't believe they got hurt at work, or it's because of the job. The next day, it's an occupational disease entitlement appeal case, like cancer. They're all so different, and they're so interesting, and so very challenging. In the last 7 years or so, I've focused my work on estate claims for the survivors of emergency responders, so firefighters, police officers, or paramedics who have died by suicide due to post-traumatic stress disorder because of what they witnessed on the job. These are not only financially rewarding cases, they're also very emotionally fulfilling cases. My kids always say, "Mom, you raised the bar so high. How do we ever find work that we're gonna love so much?" And I say, just keep looking. You'll find it. I'm gonna bet that that wasn't what you expected to hear this morning. And I'm going to tell you that I just lost my spot. By setting up a practice in a city like Windsor, which is where I'm from, or in any small town, I regularly send referrals to my personal injury lawyer colleagues all the time. And they send me WSIB appeals. We respect each other. We don't even ask for referral fees. We're happy. Each other will take care of our clients. We don't ask for anything more than that. Five years ago, when I was first elected as a bencher, a newly elected lawyer bencher told me with shock and awe. But I was the very first licensed paralegal that he had ever met. He told me he had worked with many paralegals, but never a licensed paralegal. In a strange way, because he was a strange little man, I was honored. It was clearly an oddity for him, and I told him that like every other licensed paralegal, I had blood running in my veins, and if he pinched me, I'd say, ouch. I also explained to him how licensed paralegals were different from paralegals who were not licensed, which was clearly perplexing to him. And I wasn't sure why. And so, this morning, I'm going to tell you 5 facts about licensed paralegals, and maybe you can keep track to see how many you know. So fact number 1, did you know licensed paralegals were first licensed by the Law Society in 2008, so about 16 years ago, in order to fill an access to justice gap for the people of Ontario. And fact number 2, did you know licensed paralegals pay annual dues to the Law Society of Ontario and complete an annual report, just like lawyers? And we must carry errors and omissions insurance, just like lawyers, and must complete CPD hours each year, just like lawyers. Fact number 3, did you know paralegals are subject to discipline by the Law Society and must follow the paralegal rules of conduct? Just like lawyers, we're subject to the rules of professional conduct. Fact number 4, did you know licensed paralegals are commissioners of oath? We're officers of the court and can apply to be a notary public, just like lawyers. And fact number 5, did you know licensed paralegals in Ontario provide legal services without the supervision of a lawyer? So for instance, I have my own WSIB appeals services practice without any lawyer supervision. The fact that licensed paralegals in Ontario can practice without lawyer supervision and operate on our own sets Ontario apart from other provinces and most paralegals in most states in the US. And finally, did you know paralegals are eligible to practice before all tribunals established under an act of legislature of Ontario or under an act of parliament and before mediators, just like lawyers? Most licensed paralegals provide legal services in what we call the big 3: landlord and tenant, small claims court, and provincial offenses, or POA. And why do they practice in these areas? They're the focused areas of courses during their paralegal college program, so they have the knowledge and they're generally there's generally demand for legal services in these areas. So most Ontarians, at some point in their lives, have a landlord or tenant problem, or a traffic ticket, or a small contract dispute that they need help with at small claims court. And for many lawyers, this type of work is simply, I don't know, maybe not lucrative enough for them to take the work. On the other hand, paralegals are happy to take that work, and many have made a full or part-time business out of it. And Ontarians are happy because they can generally pay paralegals less than what they pay a lawyer. So they're able to access justice. What else do paralegals do after the big three? Next in line is SABS, so Statutory Accident Benefits at the LAT, so the License Appeals Tribunal, and then WSIB, Workers' Compensation Law. Some do labor arbitration, some human rights, some represent before MPAC, the Municipal Property Assessment Corporation. Some represent at professional regulators, like the Law Society Tribunal. Having paralegals working in any of these areas, again, fills an access to justice gap. I can't tell you how many times in the 35 years I have represented workers in WSIB appeals when I have asked my clients why they waited so long to come and see me, that I have heard, "I didn't know you existed. I thought I had to hire a lawyer and I didn't have the money." And here I am with my little legal services practice in Windsor, servicing a few hundred clients a year, and most lawyers in the area happy to refer to me, and I'm happy to refer to them in return. Now you may be asking yourself, what are the benefits of law association, paralegal membership, and paralegal law library use? Well, there's the obvious, the referral reciprocity I just talked about. There's the increase in financial resources for your membership, where you charge paralegals for your library use and/or paralegal membership. Of course, paralegals recognize that they will have to pay something. No one's asking for anything for free. We know life doesn't work that way. This brings me to law association libraries and the importance of paralegal membership. So you know that the Law Society funds law libraries through LEARN to help satisfy the Law Society's statutory mandate to ensure competence for its licensees. And ensuring lawyers and paralegals remain competent means we're ensuring the public is protected. And undermining any of our colleagues in the legal professions, whether lawyers or paralegals, can only be detrimental to all of us and leads to further erosion of the public trust in our services. Paralegals are not going away. The treasurer made that clear last night in her remarks. Working together and collaboratively benefits both paralegals and lawyers and provides greater access to justice for Ontarians. So recently, both Middlesex Law Association and Essex Law Association opened their membership to paralegals. So kudos to both of you. And I became a proud member of ELA, along with about 20 other paralegals, as soon as I was permitted to become one. And I'll close with this. I attended the ELA annual general meeting last Saturday evening, along with Jennifer and a number of others. It was a lovely dinner, and one of the lawyers sitting at our table was talking to the paralegal trustee sitting beside me. And I want to tell you what he said. He said, "I've always supported paralegal membership. After all, we're the Essex Law Association, not the Essex Lawyer Association." And the last time I checked, you're the Federation of Ontario Law Associations, not the Federation of Ontario Lawyer Association. Let's open membership at all county and district law associations and county libraries to all licensees of the Law Society, including paralegals. And I wonder, is now the time to revisit your perception of paralegals and their role in our justice system? Thank you. Merci.
I would like to thank Michelle for coming to speak to us today about paralegals and opening our eyes to some of what they do and what they can bring to us. So thank her for coming to join us today. Chug. And additionally, I'd like to welcome Neha Chug, who is joining us today. She is the founder of Chug Law in Cornwall. She is a bencher. I wanted to say Montreal, but I know that's where she lives, not works. So, and she is speaking to us today about her initial findings from the Access to Justice study in rural Ontario. During the study, she spoke to a number of our presidents from around the area, as well as some other lawyers that practice, and I am excited to hear what she has to tell us today. So please join us in welcoming Neha.
I won't go. Okay.
I'm going to trade spots with Michelle.
Yeah, maybe trade spots.
Do what you want.
So, thank you for having me at this conference. It's my great privilege, and I've really enjoyed meeting everybody that I've met so far. I've done about 20 interviews, so I have about 23 hours of recorded interviews, which researchers would call data. It's really fascinating, but I'd love to have 100 hours of data. So if you're interested, my contact information is on the slide. I'm all over the internet. You can find me. And I'd love to meet with you. And I'm going to restate that at the end of my presentation so that you do reach out and we can talk about what's going on in your jurisdiction. So in 2022, perhaps, boredom coming out of COVID, or I didn't have anything else to do, I started to see myself in court. I saw this really interesting phenomenon happen during COVID where people were retiring, but they were closing their front doors and walking away from their practices. They weren't finding juniors to buy their practices. They weren't mentoring young people. They were just locking the front door, closing their laptops. They were out. And so what was happening, and we've seen this happen in Cornwall, where we had 6 retirements during COVID, but we had maybe 3 young lawyers come in, 2 who went to the Crown's office or legal aid. And so we saw a loss. We see a loss in Cornwall and surrounding rural areas. And I thought to myself, we can't be alone in this. There must be other jurisdictions that are struggling with this. What it manifested in for me was I do a lot of child protection work, so I would go to court and mom, dad, kin would all call me, but whoever called me first would get to be my client. And so it would result in 2 self-reps or delays in the case. We're on timelines with child protection cases, so it results in big delays in our cases. The judges have noticed it in Cornwall. We've started an Access to Justice committee in order to try and find ways to attract young lawyers to Cornwall, but we're all kind of putting our hands in the air saying, we don't know what to do at this juncture. So I wrote about it. I wrote about it in the Law 360, and I wrote about it in our local paper. No one heard my call to action. No one came to Cornwall because of my editorials. I don't know why. I thought I was compelling. Maybe I need Michelle to write my comments for me, because wasn't she compelling this morning? But I decided that I wasn't going to let it go. So because I was bored and had nothing to do, I said, I'm going to run for bencher, and this is going to be my bencher platform. We're going to attract young lawyers to rural Ontario, and it has remained my primary focus as bencher is how do we ensure that solo and small firms are supported across the province, but especially how do we ensure that the rural voice is heard at convocation. So my gratitude is to the Ontario Bar Association, who funded this research with the Chief Justice's Professionalism and Civility Grant. I'm so grateful to FOLA. Thank you to Ian and Doug for meeting me and for putting the call out on your website for meetings. Participants who are generous with your time. So my data set right now is about 20. Thank you for giving up an hour of your time. I appreciate it. Thank you for humoring me. Thank you for listening to my questions. And future gratitude for any participants that I meet in the coming future. So the problems I identified. The loss of the local lawyer. What has happened to our Main Street lawyer? What has happened to the institution of our Main Street lawyer? And why are we diminishing rural practitioners? Why do we have such significant service gaps in rural Ontario? Is the problem iterative? So are rural practitioners being diminished because we don't have the equivalent amount of services, or are we not getting services in rural Ontario because we don't have lawyers advocating for it in small towns? And how do we solve this problem? Is it the Law Association's problem to solve? Is it the Law Society's problem to solve? Is it the law school's problem to solve? You all had ideas about this in our interviews, but the next question that I asked you in our unstructured interviews was, is Zoom the answer? Is a Zoom platform going to flatten access in rural communities? So the questions I asked you, and again, this was an unstructured, conversational, casual interview. There was a lot of laughter. There was a lot of anecdotes, and we snowballed in the interviews into bigger questions. But we talked about, why did you choose the location where you work? What is the attrition like in your community? And how is it being realized or manifested in your community? What are the outcomes of the loss of the local lawyer in your communities? Is Zoom Court the solution? Does Zoom Court create a 2-tiered justice system, or do its pros outweigh its cons? So the research parameters were as follows. I did a call out via FOLA. I did a 45 to 60-minute interview with practitioners, solo and small firm lawyers across Ontario. Believe it or not, I did meet with urban practitioners, Kingston to Kenora, Hamilton, Brampton, Brockville, more. I was meeting people in places that I had never heard of, and so I was really excited about that. But the interesting thing about this research is that I'm not going to tell you anything that you don't already know. And believe it or not, from Kingston to Kenora, from St. Thomas to, where do you work again, Karen? Where's that place? Dryden. I knew there was a Y in there. You're all reiterating the same themes. So I don't know if you were calling each other and coming up with your answers, but you're all reiterating the same themes back to me. So the limitations of this research, and I'm very aware of this research, is first of all, you're all leaders of the bar, okay? So I'm not hearing from the person who doesn't volunteer, goes to work every day, goes home, doesn't have opinions about policy or bigger issues. I'm hearing from the FOLA leaders of the bar, okay? And you're all in solo and small firm practices. So I'm not hearing from the Crown's office in where Karen practices about, I'm not hearing from them about their ability to hire Crowns. And I'm not hearing from, my next point is, I'm not asking people why they left. So I didn't ask the people in Cornwall, why'd you leave small practice in Cornwall? Why did you go to the Crown's office? I have my ideas based on individual stories, but I didn't ask that. So those are my research limitations. I want to talk about the therapeutic impact of these interviews. The best thing I heard was, I just feel so seen. Thanks for meeting with me. And I think this conference helps everyone connect, but at the end of it, people were really excited to talk about their practices and to reflect on why they choose to do what they do. So, redefining definitions post-COVID. So, we have 3 definitions, and this comes from the sociological literature: rural, urban, semi-urban. Semi-urban is also known as suburban, okay? I practice in Cornwall, and it was my marriage that took me out east, my husband's job. I grew up in Guelph, Ontario. I went to school in Toronto. I went to Osgoode Hall. Never in a million years did I think that I was going to be in a Franco-Ontarian community called Cornwall. I had never even heard of it. But my husband's job took us to Montreal, and I do the reverse commute to Cornwall every day. And now I can't imagine practicing anywhere else. I've had offers in Ottawa. I've had offers from Crown's offices. And being in solo practice is deep in my blood, and working on Main Street in a small town is really the job for me. But we have to redefine definitions, and this came out of the interviews with everyone. So today you can work from anywhere. You can live in Burlington, and your practice can be in Cornwall. You can live in Toronto, and your practice can be in Mississauga, or vice versa. Many lawyers during COVID moved to their cottages. Is this a rural practice? No. Not, in my opinion, no. What about the urban lawyer with a branch office in a rural location? Is that a rural practice? It's still an urban lawyer. They're making most of their money in the urban center. So what I wanted to focus on was where physical addresses were. So where do they report to the Law Society in terms of their main office? But what about the new brand of lawyer whose physical address is their home? This is really starting to... Cheryl talked yesterday, Cheryl Saran talked about the data that the Law Society is pulling. And full disclosure, I am on that committee as a bencher. But it's skewing the data because so many more practitioners are working from their basements. And what I've learned from all of you is that where you work is deeply personal. So it's family, history, and roots. And I'm going to tell you that the number one predictor of where you determine your law practice is going to be is love. It's love. It's relationships. It's family. It's help with kids. It's where your spouse practices. It's where you're looking for love. It's love. So I'm from X. I came back to X. My spouse's family is from X, so we returned here for help with the kids. I was hired here for articles. My wife liked it here, so we stayed here. We made a home here. So that is the biggest predictor of where you practice. What also has come out of the research is the othering. So there's the them and us that happens, the us and them. So when they come here, when the urbans come to my home, and in Cornwall we say this, we say, when the Ottawa lawyer comes in, I met with him for an hour, but then he hired someone from Ottawa. Or when we, the Cornwallers, when we go there, right? So when I go to Ottawa and they say, Anea, what are you doing here? You okay? Did you get lost on the 417? What happened? So that started to come out of the literature, started to come out of the data, my interviews with you. So they don't know our local ways, so it is a big disadvantage for them. We go there, so urban lawyers say, we go there, we figure it out, and we leave, right? We don't stay, we figure it out. And usually what they do is they call one of us. So they call a rural lawyer and they say, I'm trying to file this notice of application. Who do I call at the court counter to get this out the door? But there is an us and them relationship happening with small town lawyers and those from the outside. Rural lawyers are rural institutions. We are access to justice institutions. We're the pillars of our community. We're much more than just law firms. We are access to justice hubs. So we usually have front doors with our names on it. People come in and they'll say, I've got this legal issue, but I've also got a mental health issue, and I've got a landlord-tenant issue. And I can say, and all of you could reflect on this, that you could say, you're gonna go see Michelle about your workplace, your WSIB issue, and you're gonna go to the mental health agency down the street, but you represent something much bigger than within the communities that you come from. You all reflected on collegial and friendly bars, with this collegiality extending to court staff and all justice system participants. Most of you are on first name bases with the person that you need to sweet talk to get your applications in. You all know them by first name. Your local practices are knowledge hubs for court procedures. I think I reflected on that earlier. And you're often drawn upon by lawyers from out of town to help them get their filings done. The Zoom lawyer. You all have a love-hate relationship with Zoom. You love it. You love what it's done for your daily schedules. You love that you've got a motion list that you can do really quickly, or a first appearance list. But you hate it because you miss your friends. You really miss your friends. You're all nodding. We miss you guys. You all miss your friends. You miss the handshakes. You miss the hallway conversations. And it flattens the playing field. It improves access to justice, but it's just not the same. The very fabric that weaves together small town practice has been lost with Zoom Court. Small town practice is more than bottom lines, it's about lifestyles. Many of you reflected on keyboard warriors. I don't know what happened over COVID, but a lot of people became keyboard warriors, sending flippant, angry emails, just kind of off the cuff, not thoughtful, not reflective of the hallway conversations that would often be had. So there's something missing. Zoom has done great things, but there's something that's really missing. And the common theme was that your generation, our generation, is really the last, that we're not seeing lawyers coming in to replace us. So like I said, from my personal story, lawyers are retiring, locking the front door, leaving without a predecessor. This was reflected in account after account after account, that people were leaving and not having succession plans. Succession plans in this indication is different than what the Law Society indicates a succession plan is. For the Law Society, a succession plan is, what's your plan for your files if something happens to you, if you're incapacitated in any way? Succession plan that I'm speaking of is, who's going to replace you and the institution that you represent for your community? So family law legal aid has been hit by far the hardest. The comments coming out is that we are grinning and bearing it, and many of you say, well, I'm just not taking the files anymore, but we're grinning and bearing the outcomes of it. There is a glut of self-reps as a result of it, not as a result of, not qualifying for legal aid, or the fact that they could have otherwise qualified for a lawyer. It's just that there's no lawyer available. Other problems, law school debt. There is a legal aid crisis. People are not taking legal aid certificate. Interestingly enough, what has come out in many rural communities, small communities, is a housing crisis. I'm not sure if this is from the rise of Airbnb or rise in rents during COVID, after COVID, but young people are not able to find apartments. So a job offer could be extended, and young people are not able to find an apartment so that they can reside in the local area. Government is hiring at a rapid rate, and rural lawyers are advising that they can't compete. They just cannot compete with what government has to offer. Solutions, I think there's some widespread acknowledgement that if we don't refresh, we will be facing a new reality, and it will be Zoom that will likely be filling that gap. When I asked, have you hired an articling student, though, and this is the interesting part, is that the answers that I would mostly receive were, I don't have that kind of practice, I'm winding down, I don't work enough to support a junior, there's no applicant pool, I don't have the resources to go through the hiring process. And so I'm going to say this very gently, but I want to know, are we the problem? Are we responsible for this problem? Or do we bear the responsibility of doing the hiring and attracting young lawyers to small towns? And overall, I asked if Zoom was a solution. Zoom is great to an extent, but it's not the whole answer to the access to justice crisis. So other solutions, Law Society incentives for lawyers who go to underserved areas, debt relief, improved legal aid, incentives for hiring lawyers, and then presentations at law schools. Let's go to law schools, let's do a jamboree, let's go see law students, show them how great it is. But I'm gonna say this again, if we don't take on young lawyers, if we don't create space for them in our firms, then all of that is, it's going to have no place for lawyers to come to. So my conclusion, interim conclusion, there's a collective desire to preserve the presence of local practitioners. You all love your jobs, you all love where you work, you want to preserve it, you don't want it to go away. But there's no succession plan for your local communities of practice. And maybe that's something you take back to your law associations, and because it's not an individual succession plan, it's a community succession plan. We need to make sure that we refresh our community of practice. Again, I'd love to interview more people for my data, and my report will be ready at the end of August. Thank you.
That was great. Thank you. Thank you very much. That was great. I really enjoyed that. It certainly is an issue that FOLA is focusing on. Our next speaker is Jennifer Leach. She is the Executive Director of the National Self-Represented Litigants Project. She has a JD, an LLM, and a PhD in law. She focuses on access to justice and legal ethics, and she is here to speak to us about self-represented litigants.
Okay, thank you very much. And thank you for having me here today. Thank you, Ian, for inviting me and to FOLA. I think this is the last talk of the day. Yes, so, okay, we'll try to make it succinct. Kind kind of builds on some of the ideas that we've already heard from this morning in the context of access to justice. So I'm going to drill down in one particular sphere, which is the notion of self-represented litigants. And I want to sort of highlight the sort of challenges, the questions and the challenges that self-representation raises, not just for the legal profession, but for the kind of administration of the civil justice system. And I am going to focus on civil justice, partially because that's what my organization does, but also because we do have the legal aid, whatever we may call that net, on the criminal side. And there's no real equivalent on the civil side. So I want to talk about a little bit about self-representation, a little bit about access to justice, and then link it up with an idea that our first speaker was talking about, which is access to legal information and to the law libraries, which we see as a really important part of an access to justice agenda. So as my co-panelist just has also mentioned, I mean, we do have a bit of a crisis in access to justice in Canada, and it's not just a Canadian thing. It is an American thing, it is a UK thing, it is an Australian thing. And what we're looking at right now is, in some capacities, a tipping point where we have more non-lawyers going into court than lawyers. So in civil justice, the numbers right now are about 40% of all cases involve a self-represented litigant. In family law, particularly in places like downtown Toronto, large urban centers, we're at about 80%, which is really quite something when you think about it. The areas that are generally impacted, of course, family law, and there's lots of reasons for that we could sort of dive into, but we don't really have time today. But on the civil side, generally, housing, debt, consumer-related, employment are all areas, personal injury to a lesser degree, because we have notions of contingency and such. But those are kind of some of the areas that are predominantly, that we see self-reps in. And then, of course, the whole administrative system as well. So a lot of the tribunals are seeing, and we're in some respects built for non-lawyers, but we're seeing really significant numbers in some of those tribunals as well. And we know as well that there are associated delays and increased costs with self-representation in the civil justice system. As a consequence, what we are concerned about is this idea that people are not able to kind of fairly and efficiently resolve their legal problems. And the social science research tells us that when you can't resolve your legal problem, that creates more problems. So the example I always use with students is, if you have a problem with your job and you are wrongfully terminated, then you lose your salary and you can't make mortgage rents. And if you can't make mortgage rent, you are out of housing. And if you're out of housing, you then have related issues with keeping your family together. So you can see how all this snowballs from these types of relatively small, the term that gets used sometimes are little injustices to start with. So the consequences of not promoting access to justice. One is unfairness and sort of, problematic results in individual cases. Justice Lowers from the Court of Appeal said in a case a few years ago that being a self-rep and going into court and sort of, managing your own trial is like being a fighter going into a ring with one arm tied behind your back. So there's an unfairness there that can result from just not being knowledgeable or experienced in the practice of law, which self-reps aren't. Recent legal needs study said 33% of the people that were questioned, it was a sizable study done across Canada. Basically, people said, I don't get my legal problem dealt with because I don't think there's no one there to help me, and I don't know where to turn. And the problem with that, of course, is that breeds a real sense of mistrust and disengagement from the civil justice system, which is problematic as well. That has, in turn, kind of lasting impacts on the legitimacy of the civil justice system. And often self-reps will say, even if I manage to get into the system, I'm not treated very well within it, and that's a problem. All of that, of course, raises other issues as well, like I said, about delay and additional cost when self-reps are struggling to participate without the right information and direction. So we at the NSRLP feel that there is a really important link between the access to legal information, and I'm going to go in a minute to what I think that means, and access to justice more broadly for self-reps. So the NSRLP, I don't know if anyone's familiar with our organization. We have basically three mandates. One is we do research. So we do empirical research around issues of access to justice, mostly involving self-represented litigants or civil justice process. We do advocacy that prioritizes the sort of issue of self-representation in policy and civil justice reform conversations. And we generate resources for self-reps. So if you have a situation where you have a self-rep on an opposing party on a file, you can direct them actually to our website. And we have primers, we have written resources about different aspects of the process. We also do a family law litigant school, which is a 12-week program where family law litigants learn about different aspects of the family law process, and they hear from judges and lawyers and academics and law librarians, and they have a chance to do a Q&A. And I'm going to highlight that because I think that's a really significant piece that I'm going to link up, hopefully, at the end with law libraries. So who are self-reps? I think one of the things we have to remember about self-reps is it's as important to know who they're not as who they are. So what do I mean by that? One is the mistaken belief that most self-reps choose to be there. They don't. They don't want to be going into court and arguing their own case. Obviously, there is a small component that I will recognize do, but the vast majority do not. They know they're typically up against lawyers who are knowledgeable and experienced in their field. That's not a great place to be. And so that's the first thing that we have to remember about self-represented litigants. At a minimum, we tend to think of them as sort of, clogging up the system. They don't really belong there. They don't have law degrees. They don't know what they're doing. And at worst, we tend to sort of lump them together as vexatious litigants. But the demographics of self-reps tell us a slightly different story. So 70% of self-reps, and we kind of do our own intake surveys, and our data matches up with other research, is that 70% have post-secondary education. 44% have at least one university degree, and another 22+% have a college diploma. The income ranges are interesting. So 50% have an income of $50,000 or less, but 20% have an income over $50,000, and another 20% on top of that have an income over $75,000. So what is this telling us? Well, first of all, to contextualize it, middle class in Canada is somewhere between $50,000 and $120,000. Obviously, we're a big country, there's urban and rural areas, so it does range differently, but the median in Canada is $64,000. So what this tells us about self-representation is that basically self-reps come from all walks of life, and they are generally in the sort of lower middle class. Obviously working poor as well, and there are some safety nets there for them, but not many. The numbers are also growing, not shrinking. And we see self-reps now in pretty much every court in Canada, every administrative tribunal. What are the causes? The causes, generally speaking, are that most people cannot afford to sustain a lawyer. So 69% of the self-reps that we have surveyed start with a lawyer, and then along the way lose that lawyer because they are no longer able to provide further retainers. So when we contextualize again that information about income, we see that people have the ability to pay for some legal services, but then run out. And there's a sort of clusters of problems around that. In addition to those financial barriers, we obviously know that there are other barriers that individuals face when they try to access lawyers. And this morning, we are also hearing as well a further kind of layer to the notion of an inability to access legal services. So what are the challenges then that self-reps face? I break them into three main categories. One, procedural. And what I mean by procedural is the notion of understanding, and I think you were even saying sort of when urban lawyers come to a rural setting, they want to know, who do I file, who do I have to speak to? What's the access like in the court? What's the process there? We obviously see that with self-reps generally. They don't know what the procedures are for courts. They don't know how to prepare for attend at court. They don't know the local practices with courts and tribunals, how the steps fit together in a piece of litigation. One of the things, and I was a litigation lawyer, one of the things that I think that we do as lawyers is not only provide substantive kind of, here is the law in this area, but we also advise our clients on how they're going to proceed through a matter. What's the best way to get where you want to go? That strategic piece is really significant, and obviously self-reps don't have that. They are also often the only non-lawyer in the room. So even though we have these really large numbers of self-reps, it's interesting to note that most of them are on files with lawyers on the other side, which is a really sort of challenging dynamic for both lawyers and courts. Substantively, where to find information, what the law is in a specific area. Where would you even begin if you didn't have any sort of information about law? But also what information you can trust. There's plenty of legal information online if you Google a question, but we all know how to evaluate the sort of legitimacy of some of that information. And this is now, we are seeing further complicated by AI and ChatGPT, who are, of course, being sought out, with the sources being sought out by self-reps, and they're getting problematic answers to both information and advice. And then attitudinal. Some of those perceptions about self-reps really inform the way that they are treated and responded to by courts, lawyers, court clerks, everyone that sort of already exists in the system. But at the same time, what's interesting, and we hear this from judges sometimes in cases, that they are expected to act like mini lawyers. They are told when they come into court, I'm going to treat you as if you are a lawyer, this is your case. And obviously, they're not lawyers. They haven't gone to law school, they haven't articled, and they don't practice. What we also know, interestingly, though, about self-representation, and including in the context of, I used to work at Law Help Ontario, which gave summary advice, is that some people, I'd say there's a good portion of them, with the right assistance, support, information, can actually resolve their legal problems without full representation. Not everybody needs a lawyer that carries them through from start to finish. There's different ways that we can sort of provide support to individuals, both as lawyers and as non-lawyers. But what people really want is some kind of human interaction when they're trying to navigate a case. A pro bono study recently that we were involved with said that the preferred methods of interaction were telephone or in person versus Zoom or chat, like online conversations. So given this type of background on self-representation, what's the link to legal information? It's important that, and we're all familiar with the notion of public legal information and education, but I also think there's an information literacy component. And what I mean by that is giving people the ability to evaluate, to understand, to evaluate, and to use information that is trustworthy and valuable to them. So the flip of that, I make the pitch for, is that if they don't have the right information, then what happens is that people think they have rights they don't have. They think they have cases that they don't have. And that is actually problematic in our system. That means that there are cases, the wrong cases might be going to court. So the right cases might not be going and the wrong cases are. So there's a really practical component to getting the right information and making sure that people understand the information that they're getting. I always use the example of Donahue and Stevenson. So Donahue and Stevenson was a case that was done on a pro bono basis. It was a summary judgment motion that obviously went to the House of Lords in 1932 and changed the way we think about negligence law. But it was the lawyer for Ms. Donahue who took on the case pro bono. She had no intention of pursuing a claim against Stevenson's ginger beer company. And I think, when you think about how powerful an impact that case has had on our common law legal system, what are the other cases that we need to be thinking about or we're missing if we're not sort of encouraging access to justice with the right cases? So, pitch for legal information, the right legal information, trustworthy legal information. What's the link to law libraries? So notwithstanding that there are law libraries that are obviously not public-facing, we believe that law libraries have a really important role to play in the sort of generation and support of legal information within communities. So we know that the same pro bono NSRLP study recently that asked where people kind of turn to get legal information. For the NSRLP, 56% of the people that answered the survey said they got it from law libraries or public libraries. So they're going to libraries. I mean, if you think about it, it kind of makes practical sense. Where do you go to find out information or direction? You're going to go to a place that has a ton of information, and that's public and law libraries. So what is the role of local law library? First of all, it's the ability to sort of address the needs of the particular community in which it is situated. And the added bonus of that is community building. And I think what we're talking about as well in the context of remote and rural practice bars is this idea of community as well. So there was a small research project undertaken by a person named Ab Curry who works for the Department of Justice. He set up a van in, I think, Wellington. I don't know if anyone here is from Wellington, but in the summer, and he would park it in the middle of town, and it was basically like, come and have your legal questions answered. No issue, no retainer, no anything. And in the summer months, they served over 500 people, just people coming up. And it wasn't always because people had an actual legal problem. They had a legal question that they just didn't even know where to start with. And that was really responding to the needs of that community. What we also know is what might be needed in Aurelia is not necessarily what's needed in Sault Ste. Marie or downtown Toronto. So law libraries, local law libraries, allow us to take legal literacy to the community in which people are living. So it allows those centers to provide resources, referrals, and valuable information that's reliable. One of the things we know about legal information and self-reps is that they're constantly cobbling information together. So they go online and they Google something and maybe they see a memo from a law firm that tells them about a new case and they're trying to figure out what that new case is saying, and then they Google e-laws or something else. But they can't put it all together. Law libraries allow them to do that, allow the instruction to be, here's the area of law, here's the jurisdiction, here are the leading cases. I'm not giving you advice, I'm still giving you information, but it's all in one place and it's all put together. It also allows for, we think, partnerships with local bars who are able to provide some access to justice. We had a project at the NSRLP some time ago, which was Lawyers in the Library. And lawyers would volunteer one night a week or maybe one night a month even, to come, and they would just answer legal questions for people. It also, there's a really, and my last point, I'm sure we're out of time. So last point is all of this sort of centering around centers, law libraries, is the idea that you actually get to communicate with people. You get to talk to someone, you get to ask them, you know, if I have a family law matter, what are the statutes that I have to be sort of concerned with in Ontario? That is invaluable to self-represented litigants, and it's easy to do from the side that has all the knowledge. So the last thing I want to say is the problems of access to justice are not going to be, you know, solved with one solution. They are complicated. They are sort of varied across regions and jurisdictions. But we think that the focus on information and centers is really key to helping communities of self-reps. So I'll finish there. I'm sorry I'm out of time. Thank you very much.